represent in file 22-5165-FH, people of the state of Michigan versus Eric Molitor, Michael Null, and William Null. We can start out by having the attorneys put their appearances on the record.
Good morning, Judge. Bill Ralston on behalf of the people.
Good morning, Your Honor. Dan Graham on behalf of the people.
Good morning, Your Honor. Phil Jock on behalf of the people.
Christina Nunzio on behalf of defendant William Null.
Damien Nunzio on behalf of defendant William Null.
Tom Sliber on behalf of defendant Michael Null.
William Barnett on behalf of Eric Molitor.
Thank you all. The record can note too that the defendants are all present in the courtroom as well. I have a couple of things that I want to go over before we bring the jury in, and certainly allow the attorneys an opportunity to address anything that they want as well. The first thing is to welcome everybody. This obviously, for all of the mantra that I've had for staff and the attorneys for the months that have preceded this, to say that this is just like any other case. It certainly is not in terms of the attention that it has received, and in terms of the number of people that will certainly be paying attention to it. But it is just like any other case, any other trial that's going to be conducted in the state of Michigan today, because we follow the same court rules, the same rules of decorum, the same rules of evidence apply. It doesn't matter what the charges are. If we were here on a retail fraud first case, it would be just the same exact process. And so as I told the attorneys from the first time that I spoke with them, this will not be a circus. This is not entertainment. This is to determine a very serious issue, and we will allow the jury to do just that. Everyone in here, no matter the capacity, is a professional. I expect everyone to behave as such. We certainly have gone over the rules of what certain folks can do and what they can't do. I don't think I need to address all of those here. But we're going to keep this case in the lane, and we're going to stay between the lines. The attorneys have all been practicing for a long time. They certainly know what that means. They know how to do it that way, and I have no doubt that they will. One thing I will ask from them, there may be objections to exhibits, things that we need to discuss outside the presence of the jury. You all know that before I do. I will obviously be the one to make the determination as it comes to that, but if you do think it is something that we should discuss outside of their presence, if you could just give me a heads up so that I know to excuse them, and then we can certainly do that. Obviously, for the folks that I will just group under the title of media, and everybody here, there is a live stream going, 2 channels actually, as well as a third camera that may be recording, so please be aware of that. We've had multiple discussions with them. They know the rules of what they can and cannot do. There may come a time where, because of a certain witness testifying, for example, that someone may request that the video feed be turned off due to it being an undercover agent, for example. That's a determination that the court will make each and every time it becomes a request or is appropriate. Certainly, if the court were to rule that the video feed needed to be turned off, for example, that would obviously still include still photographs as well, so any visual would be blocked at that point. The other thing that comes with that, and the number of attorneys and everything else, are all of the cords in the courtroom. So it may seem simple, but please watch your step. There is a lot of stuff here, and I don't want anybody to trip and get hurt. Exhibits are going to be displayed on the screen. Is that generally correct, Mr. Ralston?
Yes, sir.
So they will be on this side.
I'm sorry?
They'll be on this side?
Yes, sir.
Okay. Because obviously everyone can see the witness stand has been moved so that all of the attorneys have a view of that individual, obviously. And if anything comes up in terms of movement, we can deal with that. The court did send to the attorneys yesterday the proposed set of what I'll refer to as initial instructions. That would be the set given to the jury after or during, I suppose, when the Chapter 2 instructions are being read by me. My general practice is not to give them that full stack because, quite frankly, 30 pieces of paper or whatever it would be, I don't think would be helpful to anybody. So what my normal practice is to give the jury 2.5, which is presumption of innocence, burden of proof, and reasonable doubt. Given the circumstances of this case, I would also propose giving them 2.22. That's the multiple defendants, and they have to consider the evidence in law as it applies to each defendant. And then the 2 instructions for the charges, 3.8.3a and 11.34. I did send those out, or have our staff send it out to the parties ahead of time. There were some objections made, especially relative to issues that we had discussed in the past. I understand all of those. Those are the initial instructions based on the fact that nothing has been presented yet, that the court would propose. Obviously, if there are other instructions instructions in terms of the final set that are requested by the parties. We'll deal with that at that time. And so I guess when I say, are there any objections, my first part of that is, are there objections to only providing these instructions as opposed to all of the Chapter 2s? And do you object to the language that was included in these from the court? Let me start with the people.
We don't have any objections to what the court proposes. We did ask for the court to include a more detailed instruction as to personnel. I think the court ruled on that before, and I think it would be appropriate to give that in preliminary instructions too.
Okay. Well, I think as with the other instructions that were requested by some of the other parties, given that no evidence has been presented and there's been no challenge to that, so to speak, factually, I'm not going to give that. I wouldn't give that instruction at this time. Again, if it becomes necessary in the final set, we can certainly discuss it at that time.
And this is important because obviously how we handle opening. Does the court intend to give that personnel instruction, the definition of personnel being singular at the end?
If it were to become an issue where something else was presented to the jury so that there is an issue that needs to be clarified, yes. But the parties are, so for example, you are able to tell them that the definition of personnel can include oneself. If somebody else were to counter that, then it may become necessary to propose an instruction.
Okay.
Does that make sense?
Yes.
Mr. Nunzio, in terms of the set of preliminary instructions that were proposed by the court?
Your counsel had already submitted a proposed set of instructions of which the court had denied, so as for purposes of the appellate record, we're continuing to object to those so that the appellate record doesn't believe or show that we've waived our objection. If we concede or submit additional instructions, it could be deemed a waiver. So we're continuing on with our objection with respect to proposed instructions at this time. And just for purposes of clarification, to follow up on Mr. Barnett's, Mr. Rolston, his statement, the personnel definition, is the court adopting the federal definition with respect to bringing others as well as including oneself in that definition, or is the court just
I'm not adopting the definition from the federal system if that's what it is. I'm simply saying that in the state of Michigan, my ruling is that the term personnel can include oneself.
Can include, but the presumption is that can is following up on another element, that being bring other people and can include oneself.
Correct. I think the term personnel can include other people, but it can also include oneself. And
Okay.
it can be referenced as such by the parties.
Okay. And I use the federal definition because that's what the federal definition is.
Sure.
So, is the court entertaining any other objections at this time, or?
Let's deal with the instructions first, and I'll give each party a chance to address anything they want.
So I think that's all we have. Thank you.
Okay. And I would note for the defense attorneys, I understand perfecting an appellate record. If objections have been made previously, meaning there's been motions perhaps, such as with the jury instructions, by saying you agree to or have no objections to this initial proposed set, I don't view that as a waiver. I think that those are maintained. We're not dealing with that issue specifically, but obviously if you want to put that just to protect it, that's perfectly clear.
Thank you.
Mr. Cyber?
Yes, sir.
In terms of the initial or proposed set?
No.
Okay. And Mr. Burnett?
No objection. I just want the court to know I did file my proposed jury instructions. Just wanted the court to look those over, the court to follow them. Would like to join in Mr. Cyber, Mr. Nunzio's previous and current objections to the definitions, for example, everything that they filed relative, that's probably more in depth than my objections than were proposed jury instructions. They did basically, at least one of them, filed the same instructions that were tied to the motion that the judge, Your Honor, has already turned down. But I would just ask the court to allow me to adopt by reference their arguments and mine. And if the instructions you're looking at this morning are standard, I think that there's no objection.
Okay. And all of those objections for all three defendants are maintained for the purposes of the record. I would also at this time order that witnesses be sequestered. That will apply throughout the duration of the trial. So no witness who is subpoenaed can be in the courtroom, listen to any testimony or anything along those lines until after their testimony has been completed and they are released from their subpoena. The one exception that I would make is one that we always do, which is for the lead investigator, which I understand would be Special Agent Nicola. Is that correct?
That's correct, Judge, and as well, this is a joint investigation. Detective Sergeant Carl Schmitz from the Michigan State Police is in the courtroom, second row with hands raised. I'd ask that he be accepted too.
Okay, any objection from defense counsel on that?
No objection.
No objection.
None?
Okay.
I'm sorry, I left out Mr. Harris. Special Agent Harris from the FBI is also, was a partner and, co-investigated this as well. We'd ask that he be accepted as well. He'll be running our audio visual. I don't actually anticipate having his witness.
Okay, based on those circumstances, any objection, Mr. Nunzi?
No objection.
No objection.
No objection.
And just for order and ease of the court, since how you guys are seated now, that's the order the court's going to go in, just because it's easier, quite frankly, for me to remember. I already mentioned about the courts. Also, I think somebody asked at one point, I don't have any issue or objection if folks want to leave stuff in the courtroom. It is a public building. It's obviously locked during certain hours. This room will not be locked, however, so just take that into consideration. But certainly if anybody wants to leave everything rather than having to move in and out every day, that's perfectly appropriate. So, that is what I had to cover. Let me go to the parties. We'll start with the people. Mr. Ralston, anything for you before?
No, thank you very much, Judge.
Okay. Mr. Nunzi.
Yes, Your Honor. It has come to our attention that obviously that the state is going to get into certain items of evidence, uncharged acts, that being conspiracy and potentially other crimes. The defense has not received, I've checked with everybody, if I'm mistaken, please have the state speak up immediately. We have not received any notice pursuant to MRE 404B, prior bad acts, with respect to uncharged acts, okay? And so that's the rule that governs the admission of evidence and how the court is to instruct a jury relative to uncharged acts and the like. And so since we did not receive a notice pursuant to statute 14 days prior to today's date or prior to the jury selection, we're requesting and objecting to any uncharged acts coming in at this time. It governs uncharged acts, Your Honor, because they're going to be alleging that the defendant sitting here today conspired with Barry Croft and Adam Fox with respect to uncharged acts. And I don't know how the court's going to deal with that, but they are supposed to file by statute a notice under MRE 404B. And therefore, we're objecting to any testimony that comes in relative to any uncharged acts, prior bad acts. And as the court knows, under 404B, it goes to plan, motive, scheme, design, intent. Not to show propensity, but to show the elements that I've just indicated to the court. We have not received that notice, and therefore we're filing a formal objection orally here today to the admission of any uncharged acts that our clients are facing by virtue of witness testimony and evidence to them. Thank you.
Mr. Seidel.
Judge, we would concur with brother counsel. We have 2 counts, and that's it. Thanks for running.
I join.
Mr. Ralston, responsible.
I see that if they think that we're getting into that territory, the appropriate thing to do would be to rise and object.
Will any such possible material come up during opening statements?
No, I'm sorry.
I'm just checking.
Yeah.
Okay.
There's an intersection here too, obviously, the co-conspirator statement ruling
Sure.
the court's issues, so.
Yep, that's fine. Well, what we'll do at this point is the objections noted for the record, we'll table that until, one second, Mr. Seidel. We'll table that until it possibly becomes an issue and deal with it at that time.
Okay, because it's an admission issue, whether or not the court will accept the testimony pursuant to MRE 404B. And it's uncharged act. At some point in time, counsel, joined or unjoined by the rest of the layers up here, you're going to have to make a decision on how you're going to instruct the jury, because they're going to allege this giant conspiracy. We're going to hear ad nauseum, conspiracy. They haven't been charged with conspiracy, and they could have charged conspiracy, but they didn't. The fact of the matter is, at some point in time, this court's going to either have to give some form of instruction or a curative instruction regarding uncharged acts, because not to do so would be a violation of our client's due process rights to a fair trial.
And that's perfectly fine. I'm familiar with the rules of evidence and how they work.
Judge, just Mr. Rolstein alleged to it that he may.
I'm sorry, it's Ralston.
Ralston, I'm sorry.
Thank you.
No offense. Alleged that he may go into co-conspirator in his opening statements, and that could be cause for a mistrial. Thank you.
Mr. Barnett?
Can we approach Your Honor just for another separate issue?
Next, we're going to take a short break. Back to the attorneys in the chambers, please.
All rise, please.
No, thank you, Your Honor.
Mr. Seibel?
No, thank you.
Mr. Bennett?
No, Your Honor.
All rise for the jury.
Judge Hamlin is number 1 back row.
Yes.
left. Okay.
So, welcome back, ladies and gentlemen. This is seat number 1. This is seat number 10.
So juror number 1's going to be back row. Which one?
Why don't I just stay down there?
Yeah. Number 1's
So juror number 1 is back here, juror number 10 is here. There should be 9 seats in the room.
1 through 9, 10 through 18. Is your first one?
I need to look.
Okay, the second one for sure. 1 through 9, 10 through 18. Oh,
So for the folks in the back row, watch that it is a rise, so be careful with this. It is
You're the 5th chair in the back row. One through 9, 10 through 18. One is the first one. Yeah. It's 1 through 9, 10 through 18.
Okay, everyone may be seated. Back, ladies and gentlemen, you'll be surprised by the end of this, how good you all get at that. You'll come in reverse order and everything by the end. You'll recall during the jury selection process, I explained your role as part of this. Obviously, there are a lot of people in the courtroom, given the nature of the case, that might not otherwise apply. You'll also notice that there are media and there are cameras. What I want to let you all know about are the protections that apply to you in a case like this. None of that will ever be pointed at you. No camera will ever show your face. No one will release your name as part of this process. There will not be any still photographs, anything along those lines. Obviously, the first job of the court is to ensure that a fair trial is conducted. Maybe 1B, because I don't want to describe it as number 2, is the safety of everybody involved. Nobody more so than the jurors. Okay, so don't worry about any of that. Your job is to simply pay attention to the evidence in the case and ultimately make a decision. Okay? I do want to let you know, too, I see everyone is wearing their lanyards. Please, when you're on the campus area, that would be anywhere in the general vicinity of the county buildings, keep those on so that way everyone can identify you as a juror. That way they know not to talk to you and any casual conversations that may be going on. And again, like I told you before, if you see folks, they may kind of duck away from you or turn away. That's nobody being rude. It's just they're following the same rules that apply to you, which is that they can't talk to you or have a good morning or hello or anything along those lines. Okay, so please don't take that personally. For today, what we'll do, we'll take a break at some point this morning and give you all a menu, or each of you a menu, I should say, and then you'll pick from that what you're going to have for lunch, and then it will be provided and delivered to you, so that way you have it at the courthouse, just to reduce the amount of time that you could be in contact with other folks and those kinds of things. But we probably won't do that every day of the trial, but certainly at the beginning I wanted to do that until everybody sort of gets a feel for the mechanics of this and how it's going to work. Okay. There are some initial instructions that I'd like to go over with you. Members of the jury, you have been chosen to decide 2 criminal charges made by the state of Michigan against 3 of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So if you would, please stand and raise your right hand. Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. You may be seated. You will also receive a written copy of some of the instructions that I am going to read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. The ones that you get today, and actually you can take a little break, they will include the elements for each of the charges. So if somebody is reviewing those, like I'll read them to you in a few moments, don't worry about writing those down or having to memorize them or anything along those lines. You will have copies of those instructions so that you can use them as reference. Okay. Now I will explain some of the legal principles you will need to know and the procedure that we will follow in this trial. 3 defendants in this case are charged with the same 2 offenses. They are charged in count 1 with providing material support for a terrorist act. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant provided material support in the form of currency or other financial securities, financial services, lodging, training, safe houses, false documentation or identification, communications equipment, facilities, weapons, lethal substances, explosives, personnel, transportation, including any related physical assets or intangible property, or expert services or expert assistance to another person. Second, that when the defendant provided material support to another person, he knew that the other person would use that support or resources, at least in part, to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, Michigan or its citizens, a political subdivision or agency of Michigan, or a local unit of government. An act of terrorism is committing or attempting to commit the violent felony of murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping that was or would be dangerous to human life and was intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. Murder, assault with intent to commit murder, assault with intent to commit great bodily harm, arson, or kidnapping are violent felonies. You must decide whether the crime was or would have been dangerous to human life, and whether the defendant intended to intimidate or coerce a civilian population, or intended to influence or affect the conduct of government or a government through unit of government through intimidation or coercion by committing one of these felonies. The defendant is also charged with the separate crime of possessing a firearm at the time he committed the crime of providing material support for an act of terrorism. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant committed the crime of providing material support for an act of terrorism, which has been defined for you. It is not necessary, however, that the defendant be convicted of that crime. Second, that at the time the defendant committed that crime, he knowingly carried or possessed a firearm. It does not matter whether or not the firearm was capable of firing a projectile or whether it was loaded. A firearm includes any weapon which will or is designed to or may readily be converted to expel a projectile by action of an explosive. A pistol is a firearm. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendants are innocent. This presumption continues throughout the trial and entitles each defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. None of the defendants are required to prove their innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendants not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement. where he gives his theories about the case. The defendant's lawyers do not have to make an opening statement, but each may make an opening statement after the prosecutor makes his, or each may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyers have the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all his evidence, the defendant's attorneys may also offer evidence, but do not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and all of the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice that you may have based on the witness's race, national origin, or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions that the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. I may ask some of the witnesses' questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to court staff, who will give it to me. Do not show your question to other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. I will give you all a little cheat when it comes to those questions because if you're like me, your memory, you might forget the question before the end of the questioning. So what I always tell people, you have pads of paper. I'll get to an instruction in a few moments that'll let you know that you're free to take notes in the case. What I would suggest to you is flip to the last page, write your question down. That way you won't forget it. Don't pass it in at that time. Just simply write it down so that you don't forget. And then, once again, wait until the end of all the questioning. The chances are that one of the attorneys will ask a question that answers yours. If, at the end of that, you still have the question, that's when you would raise your hand. They'll all simply ask before excusing the witness if the jury has any questions. And at that time, you would raise your hand and pass it down. Okay? If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendants, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, those restrictions obviously no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will be secured during any breaks. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. There is more than one defendant in this case. The fact that they are on trial together is not evidence that they were associated with each other or that either one is guilty. You should consider each defendant separately. Each is entitled to have his case decided on the evidence and the law that applies to him. You can see that we have chosen a jury of 18. After you have heard all of the evidence and my instructions, we will draw lots to decide which of you will be dismissed to form a final jury of 12. Possible penalties should not influence your decision. If you find any one of the defendants guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyers' closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of these biases, though we may not express them. We may not be fully aware of some others. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have unintentionally been influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Ladies and gentlemen, we're going to begin at this time with opening statements. The people bear the burden in this case, so they will always go first. Mr. Ralston.
Good morning, everybody. Your sacrifice continues. We appreciate your willingness to serve. I think if you go back to Monday, it probably didn't dawn on any, it probably dawned on all of you rather, that if you wanted to find yourself excused from the jury, you could have, and each of you made a decision. No, I'm not going to do that. I'm going to serve. I'm going to, respond to that summons and come down here and listen to this trial. We're grateful for that. Okay, whatever your verdict might be. So let's talk a little bit about what I'm about to do here. As you heard Judge Hamlin tell you, this is our chance to introduce you to the case. Think of it as a summary or roadmap of what we believe the evidence in this case will show you. Okay. Now, as I pointed out earlier, and as Judge Hamlin did this morning, what I say is an evidence. Okay. So you might be sitting there and thinking to yourself, well, Mr. Ralston, how do you know what the testimony might be? How do you know what the evidence might be? How do you know what exhibits might come in? Well, as you're going to learn during the course of the trial, I think you were introduced to it on Monday a little bit. Both sides have the same materials, okay? Whether it be written reports, witness statements, prior testimony, recordings, photographs. We each share the same base of knowledge, if you will, okay? And that's how each side is able to intelligently prepare for trial, is by knowing what the evidence is and what testimony and exhibits are likely during the course of the trial. So let's get into it a little bit here. Terrorist attacks and mass shootings, they don't happen in a vacuum, okay? There's a build-up to these events. And after an attack, everyone hears about the signs, the warnings, the bits and pieces of information that people knew about but didn't put together in time to stop it. That's what this case is about, ladies and gentlemen. It's about the build-up and the way that these three defendants were involved in that build-up to a terrorist attack. We have laws in the state of Michigan that make it a crime to help someone who participates in that build-up. And those laws are called providing material support for a terroristic act. Okay? Cover a few rules of the road if we could. Judge just told you about the presumption of innocence. Very important. The defendants, as we sit here this morning and during the entire course of the trial, are presumed innocent. The burden of proof is on the prosecution. That's only fair. If you make an allegation, you should bear that burden of proof. Each element has to be proven beyond a reasonable doubt. Motive is not an element, but it's something you can consider when you think to yourself whether or not the elements have been proven. Okay? And the reason that's so is because motive is, we talked a little bit during voir dire, there's not a lot in life that we do that's by mistake. And one of the things that I think that you'll see here during the course of the trial is that the defendants shared a motive, and they all had a reason to help a terrorist. Court's instructions, evidence comes from the witness stand, any exhibits admitted during trial. You can use both direct and circumstantial evidence to prove an element to the crime charge. Direct evidence is I saw what happened. Circumstantial evidence is the raindrops on the raincoat and the man carrying an umbrella. Factors to consider in judging a witness's credibility: age, maturity, personal interest. Does the testimony agree with other evidence in the case? The defendants are charged with first providing material support for a terroristic act, and to two individuals, Adam Fox and Barry Croft. You're going to hear those names quite a bit during the course of the trial. First element of this charge is that they provided material support to Barry Croft, and the judge just read this to you, and you can see it with your own eyes now, and you'll get written copies of this when you go back into the jury room at the end of the trial. But it's someone who helps another individual in some way, provides something that's material, okay? And for instance, take for example the word personnel. The judge is going to instruct you that if a person provides themselves to an individual, works with them and helps them and assists them towards a terroristic attack, that's sufficient to satisfy this particular element. And when they did that, when they provided that material support, they knew that the individual, Barry Croft or Adam Fox, would use that support in whole or in part for an act of terrorism. That is to plan, to prepare, carry out, facilitate, or avoid apprehension for an act of terrorism. Now, obviously, the definition of an act of terrorism is a violent felony, dangerous to human life, and intended to intimidate a unit of government or a civilian population. There's only two elements to the first crime. I mean, that's all there is. There isn't 7 or 8 or 9, as in the cake recipe analogy. Rather, there's only 2. For felony firearm, it's the same thing. Each defendant is charged with that felony firearm, and there's 2 elements that must be proven there before you could return a guilty verdict. One, that the defendant possessed a firearm at the time he committed a felony, and the particular felony in this case is providing material support for a terroristic act. Let's talk a little bit here about why you're sitting here today. Okay, what brought you here today? And it's because of the actions of Mike Null, Bill Null, and Eric Molitor. And the defendants walked up to the edge of violence. And the evidence is going to show you that they supported 2 terrorists, that's Adam Fox and Barry Croft, who were planning an attack against law enforcement here in Antrim County. Barry Croft and Adam Fox are the terrorists that Bill Null, Mike Null, and Eric Molitor helped. Just after COVID started in early 2020, Barry Croft initiated a plan to conduct attacks across the United States in multiple state capitals, targeting sitting governors. And you can think of Barry Croft as the national movement leader, if you will. Adam Fox was his Michigan commander. And you're going to learn about the civilian army that Adam Fox was starting, and that he was working with Barry Croft, and they shared a very common ideology, an anarchist, anti-government ideology is how they thought. Barry Croft posted on Facebook, "I believe all it's going to take is one state to burn out and hang a governor, and those dominoes will start to fall." And I think you'll see during the course of the trial, the evidence is going to show you that what he's talking about there is he wanted a multi-state, coordinated, simultaneous attack on sitting governors, including here in the state of Michigan. Their plan didn't just involve kidnapping the governor. Their plan involved a 20-minute free-for-all gun battle on Birch Lake and the murder of Michigan state troopers who were assigned to protect our governor. It's much more than just the governor, ladies and gentlemen. These men were helping Barry Croft and Adam Fox towards an end of killing law enforcement officers here in Antrim County, including members of the Elk Rapids Police Department and possibly members of your Sheriff's Department. You're going to hear audio recordings of the terrorists planning their operation with defendants' help. Here are 2 audio clips of Adam Fox in the car with Mike Null and Bill Null. And listen to Fox's plan to kill the local police officers. This case is much more than a kidnapping plot. Give me just 1 minute if I could, Judge.
Sure.
Dan, come here for a minute. I'm sorry. How do I, where? Okay. Let me try it now. Yeah, sure. Judge, I'm having a problem here that I could use 5 or 10 minutes on. I apologize. I'm sorry. Yeah.
All rise for the jury.
Thank you.
If you will retire to the jury room, then we'll bring you back out when you're ready.
Apologies.
You all may be seated.
I'm sorry, Judge. You know.
As we all indicated many times, there are things that are going to come up.
Yep.
First, let's close out of everything else. You don't need this, right?
No.
You don't need that.
Yeah. Yeah. I appreciate it. Thanks, Dana. Yeah, this one's on top. Is that what the stair is crashing at?
I don't know.
Something like, I'm going to leave the next update, everybody can stay silent.
On the back, where do you have your,
Rano. Intrum. Okay.
so these should be,
All the way up. Get that butter all the way up. Right here.
yeah, hold on.
Okay. Okay, good. Part of it.
Let's go back and test this.
Yeah. Let's start on here. Let's start the,
So go down right here.
yeah, full loss presentation mode. Yeah, see? Nothing right here.
Hold on.
There you go.
You try it. Okay, so be right here. Yeah, there it is.
But it's all the way up. That's as good as
I would start with this one though. That other clip was quiet anyway.
Hey, thank you. I think we got it figured out. Can I hit the head for 2 seconds? Yep. Thank you.
curious what to see.
Okay, sure.
Mr. Nunzio,
Yes.
I want to give you guys an opportunity. I know you have work to do, but I also want to give you guys a chance to actually eat food as we've seen that with lunch. So if we need 90 minutes, that's fine.
Okay.
Don't
I don't think I'll be able to. Maybe like in between.
I mean, let's say it's 11:45. We come back at 1. So
That's perfect. Okay.
we'll work on the clock.
Just curious. That's,
Cross the bridge when we get home.
yeah.
Ready when you are, Judge. Thanks. Appreciate the break. Yes, sir. Yeah. Yeah, I can reach over and do it. I think it's a little.
All right, please, for the executive session.
Thank you. You can be seated. Okay, let's go back on the record. Mr. Ralston, technical difficulties, all set? Okay. The record can also reflect that the jury is obviously still out of the courtroom, so let me take this opportunity. Any objection from any of the attorneys to the instructions as read by the court?
No.
The people?
No.
Mr. Nunzio? Mr. Simon? Any objection to the instructions as read by the court? No. Okay, I just want to make sure we got that. Thank you. All rise for the jury. You all can have a seat. You all can have a seat. We're standing. Somebody's selling back to the restaurant. That's perfect. See, I told you. Look how much better you were the second time.
Yeah. Yeah.
see some folks brought a bottle of water or something back into them, that's perfectly fine. If later in the day you want to bring a snack or something along those lines, that's all right too. Just make sure that whatever it is doesn't interfere with your ability to pay attention. Okay? Thank you. Mr. Wilson.
Thanks, Judge. I forget who the stage performer was from the 1930s or so that said he wouldn't work with animals or children. And before computers came out, I want to thank you for your patience. Judge, can I ask the first row of lights maybe be turned down a little bit so that they can see the screen a little better?
Sure. Mr. Arden, could you possibly turn down the lights if we can figure out which row is which?
Just the first row would be great. You know, over here. I think it's just a switch. Okay, yeah. Okay, yeah. Thank you very much. Returning to my remarks here, the audio recordings that you are hearing, some are very loud, some are a little softer. That's why you're going to have transcripts provided for you. Okay, it'll identify who the speakers are, and hopefully that will be of help to you. This second piece of evidence that we believe will be admitted during the course of the trial, I'll remind you, is Adam Fox, one of the two terrorists that the defendants were helping to plot an attack here in Antrim County. And here's a conversation between Mr. Fox, or Mr. Fox rather, speaking to Bill Null and Michael Null, who were in a vehicle with him, and Mr. Fox telling both the Null twin brothers his plans about attacking the governor, state of Michigan, and her security detail at her cabin on Birch Lake.
You guys know about how many security detail, and I've heard that she was a very security detail. When she was out there, one picture there was one team. So there was like one security SPV in that person. So that's a pretty flag detail. We need about 4 or 6 minute detail. You see the equipment we have, right? Her vehicle is gone before we even get to the shore. Maybe she got 1 or 2 weeks. Okay? Well, now we deal with those. Well, we need 2, we're running 8, 9, 10, 19.
Now, ladies and gentlemen, I want to remind you that these defendants aren't charged with conducting a terrorist attack or attempting to conduct a terrorist attack or communicating a threat of terrorism. I mean, they're charged with providing material support to another who planned the attack. Okay, so try to bear that in mind during the course of the trial. As we progress into the details of the attack, I think you're going to hear the why, or the motive as we call it, which behind the actions of these defendants. And right now I want to walk you through the significant events and the defendants' involvement step by step, and you'll see that really the facts of this case are rather straightforward. These are the three defendants, or rather the three threat streams, if you will, that came together plotting an attack here in Antrim County on the governor's cabin, on Birch Lake, planning to kill her security detail and any other responding officers from the local area that came, including Elk Rapids PD and the Antrim County Sheriff's Department. The Wolverine, it's about 3 different threat streams coming together. The top is the Wolverine Watchman, and Adam Fox and his team, and Barry Croft and his team. Barry Croft was from Delaware. You might hear him referred to as the gentleman from Delaware. Adam Fox was from Grand Rapids, and the Wolverine Watchmen were based out of Jackson County. And all 3 of these groups harbored a strong anti-government, anarchist militia mentality, okay? And they referred to themselves kind of pirating or misappropriating traditional words, as they called themselves the new founding fathers, or the evidence will probably show you they considered themselves the patriots, okay? these three threat streams came together based on their shared ideology. I mean, they did not, as I mentioned, they didn't like the U.S. government, they didn't like state government, and they all desired a start to the Civil War, if you can believe it. They actually they wanted a civil war to come to the U.S. And you're going to learn a little bit about the code words they used. And they called this Civil War the Boogaloo, or the Big Igloo. Simply put, Barry Croft, who you see up there in that picture with Adam Fox, held a national meeting down in Dublin, Ohio, on June the 6th of 2020. And the purpose of the meeting was to bring people together from other states that were like-minded, who were in the Boogaloo movement, you'll hear, and to discuss the actual kicking off of a civil war in the United States by coordinating it and making it simultaneous, as I said earlier, in different states against different sitting governors. Barry, I'm sorry, the name of this meeting was the New Founding Fathers meeting, and Adam Fox attended, and so did Bill Null. Later in July, there was a training, or what they called an FTX, and that's short for Field Training Exercise. I mean, these defendants and the people they were trying to help, Barry Croft and Adam Fox, I mean, they considered themselves military almost. I mean, they had heavy weaponry and they were very serious about their business. This training in Cambria, Wisconsin was also attended by Barry Croft and Adam Fox, and it was used to help further the plan to attack Governor Whitmer. What you see is a daytime, in the daytime surveillance box there, is on August 29th of 2020, Eric Molitor and Adam Fox, with a confidential human source, an individual that was working with the FBI as their eyes and ears, traveled here to Antrim County on that date. And Eric Molitor, along with Adam Fox in the car, actually reached the threshold of the governor's cabin's driveway. Okay? They were here surveilling the cabin because Adam Fox and Barry Croft wanted to kill the governor of the state of Michigan, and they were willing to kill her security detail to get to her. And this surveillance was part of what they called recon, or reconnaissance of their target. It's what you'll hear that they called the governor. There was also a training exercise that was conducted south of Cadillac, which is the Michigan Field Training Exercise, just outside of Luther. There you see a picture of Mike Null, who was present during that training exercise. And that was held on September 11th and 12th of September. And this, the point of this particular exercise was, again, to help refine the plan to attack Governor Whitmer, to practice the skills they would need to assault her cabin and take her by force. Eric Molitor provided some specialized equipment for this training exercise to Adam Fox in the form of a radio frequency detector, which could be used to find listening devices on individuals who might be undercover agents or cooperators with the investigators to the case, recording devices, things of that sort. And it finally culminated with a nighttime surveillance on September the 11th of the governor's cabin here on Birch Lake in Antrim County. The second surveillance that was conducted on her property by Adam Fox. And on this particular evening, Barry Croft was also there, the second terrorist. The Knoll brothers were also present during this nighttime surveillance and assisted Adam Fox, okay, during the course of this nighttime surveillance of the governor's home. This is a video that you're about to see that was actually produced by the team that surveilled Governor Whitmer's cabin on September 12th. There were 3 operators in the car, and by the end of this trial, I think you're going to understand how this plot unfolded, how these defendants came to help Barry Croft and Adam Fox. I must say, though, that for the average person, it's almost impossible to fathom how brazen, how bold, and how dangerous these individuals were. These defendants decided to use force and violence to solve their problems.
Here's some fireline numbers, these green signs up there. What's numbers we're looking for?
Let's walk you through the why a little bit. You know, and the why and the motive, you know, why the defendants believe they needed to resort to violence. You know, for this, you need to know and kind of see how the defendants' anti-government ideology led them to believe they could start a civil war. So part of the evidence in this case is going to be their core identity, okay? And really what that goes to is intent, okay? And it'll shed light on, we're going to shed light on their intent through their core identity. The defendants were using COVID as a reason to voice their hatred towards our government, and they weren't shy about it. They attended protests, which was legal, and but they found very quickly that protests weren't enough for 2 reasons. One, their demands weren't being met, and also these defendants harbored a desire to inflict violence. Some of the evidence is going to be how these defendants used rallies and protests, in fact, to meet and recruit others in their plan and uniting for a common cause. Body of the evidence that I believe is going to be given to you is how these defendants created a team, if you will, and they participated in what's called encrypted chats, which means communications electronically that only the sender and the receiver can read, okay? And that's done to thwart, you know, the possibility of being discovered. I mean, they knew what they were doing was wrong, and they used this means of communication to try to thwart anybody catching them. And finally, how these defendants use their skills, training, and equipment to come together as a team. The Wolverine Watchmen was an anarchist militia that started during the fall of 2019, well before COVID started. The FBI and the Michigan State Police started a joint investigation into the group in March of 2020 after learning about some illegal weapons and offensive training they were conducting in Jackson County to attack law enforcement. The Wolverine Watchmen is one of the 3 threat streams that came together and it ended up being here in Antrim County planning an attack on the governor over on Birch Lake and her security detail. These attacks were in support of Boogaloo, which is again code for a civil war in the United States. On the right, you're going to see these are symbols of the Boogaloo movement that you'll learn about. They called it the Big Igloo. The Hawaiian-themed stripe in the middle that runs horizontally was their uniform, if you will, a way to, if you wore something Hawaiian-themed and you went to one of these protests, people would know you were part of the Boogaloo movement. 2 of these defendants, Mike and Bill Knoll, are 38-year-old twin brothers, and they were leaders in the Michigan Liberty Militia. back in 2020, and they harbored anarchist views, and they publicly promoted the Boogaloo ideology. Now, these men weren't just preppers. I mean, they were not stockpiling beans and bullets. They trained to instigate violence, and they followed civil unrest. They traveled to bring violence to other places in Michigan, and they intended to start a civil war themselves right here in our state. And these are patches that they wore on their body armor. And you can see on the left, I mean, Bill Knoll had wasn't shy about promoting the fact that he was part of the Boogaloo movement. And on the right, Mike Knoll wore the same thing. Okay, let's talk about April 30th a little bit here. I think the evidence is going to show you that on that date, the Michigan House of Representatives was in session, and they were conducting an important vote on whether to support the COVID measures that were being promoted by the governor. Now, reasonable minds can differ. That's okay. And you can disagree with an elected politician. There's nothing wrong with that. But the Knoll twins led the American Patriot rally on that date that was outside of our state capitol, and they made it pretty clear about where they stood when they were there. The Wolverine Watchmen also attended this rally. I mean, this rally was attracting this kind of group, okay? And they weren't there with the Knoll brothers, but members of the Wolverine Watchmen were. In fact, what you see here is a picture of the Wolverine Watchmen stacked up outside of the governor's ceremonial office in the Capitol. Now, the Knoll twins also entered the Capitol, and they went up to the second floor rotunda where the entrance to the House chambers is. And this event at the Capitol galvanized this Boogaloo or anarchist community. And Adam Fox later told Barry Croft that they shook the halls during this day. Adam Fox was at the Capitol too that day. Again, these individuals haven't merged yet, okay? But they're beginning to. They're there. All three threat streams, except for Barry Croft, I'm sorry, are at the Capitol this day. And you don't really have to wonder about where he's at and what he's doing. When you look at Adam Fox here and you hear what's going on in the Capitol, it's pretty plain. I'd also ask that you note his Hawaiian-themed shirt. And I'd suggest to you the evidence is going to prove that he's not wearing it by mistake. 18 days later, there's a second American Patriot rally over in Grand Rapids at Rosa Parks Circle. And Adam Fox, Eric Molitor, and the Knoll twins attended. Again, not together, but they're showing up at the same kind of event. But the short version is, ladies and gentlemen, is that these protests that they were going to, and they were using COVID as an excuse. I mean, they all harbored anarchist, anti-government view before COVID. And that's primarily what these protests were about. They were leveraging COVID to their benefit in the promotion of the Boogaloo movement and a desire to start a civil war. What these men believed, and the men behind me that are charged here, is that the people with the most guns who are willing to use violence should make the decisions, that they would be the deciders. Eventually, the Wolverine Watchmen and Adam Fox connect. And on the 20th of June of 2020, they meet in Grand Rapids, where Adam Fox works and lives at a place called the Back Shack. And Fox described his plans for violence and how he recruited the Knoll twins to these members of the Wolverine Watchmen. And he described the Knoll twins as being willing to die on behalf of the cause.
The Knoll brothers, they were mentioned already. Bill Knoll came. Bill and Mike Knoll, they were mentioned already, but Bill came, but Mike didn't. But the Knoll brothers, I have a lot of faith in their violence. They're ready to fucking stuff off. Like, they're willing to die for this shit. And we don't want to die in vain. They want to die on what's up.
Okay. What Adam Fox is talking about there is Adam Fox, if you recall, and Bill Knoll. And you don't have to remember every single event off of what I'm saying today. I mean, you're going to learn this through the course of the trial. But I mentioned before there was a meeting down in Dublin, Ohio, the national militia meeting that was to coordinate, kicking off an attack in multiple states against multiple governors. And Adam Fox and Barry Croft were there. That's Adam Fox telling the Wolverine Watchman that Bill Knoll was there too. And they began to connect in the month of June of 2020. We're going to show you what the Knoll twins said and how they revealed their ideology while communicating with each other about using civil unrest with COVID to their advantage. Before COVID started back in November of 2019, this is a Facebook message by Bill Knoll. Fuck the police, they're the supporters, they're all the enemy. Or they're all the enemies. That's before COVID even started. Mike Knoll, in March of 2020, posted that the fact that it will be the National Guard that's helping people is a pretty good indicator that it's kill or be killed. Bill Knoll on the 16th of March said, "No fear, Valhalla awaits its warrior." And you're going to learn a little bit that Valhalla is part of Viking mythology, and it's the Viking version of heaven. And in response to that message, Mike Knoll posted, "So I'm kind of excited." That's how Mike Knoll felt about the prospect of violence and another civil war. What you see here, ladies and gentlemen, is going to be part of the evidence in the case about operational security I mentioned earlier, or OPSEC, and how they used encrypted messaging and in-person meetings to avoid being detected. And this is a message from Bill Knoll, who says, who's talking about a meeting, with other like-minded individuals in the Boogaloo. Set the time. The place should be in the woods we talked about last meeting. Leave all electronics at home. This is a perfect example of the operational security that Bill Knoll practiced along with his twin brother Mike, and also Eric Mulder. This is important because it tells you a little bit about the intentions of the defendants and the fact that they knew their actions were illegal. Eric Molitor's recruitment by Adam Fox was a little more personal. And Adam Fox actually got Eric Molitor a job as a private security guard. And Eric Molitor actually covered Adam Fox's shift, because Adam Fox was a private security guard too, when Adam Fox needed time off work to go to Ohio and Dublin for that national militia meeting where they talked about kicking off the Civil War with Barry Croft, that was called the New Founding Fathers meeting. Before the FBI, well, first of all, this is a post by Barry Croft. And the post is after Barry Croft has anointed Adam Fox as the commander of the 2nd Continental Michigan Regiment. And after he does that, Barry Croft posts this on Facebook, promoting individuals to join Adam Fox's group of anarchists. These following clips you're going to hear are between Eric Molitor and Adam Fox, and they are Facebook messaging clips, okay, that were acquired through a search warrant. Everything that you're going to see here was acquired through search warrants approved by a judge. These were not things that were, found or taken without judicial permission. Okay, nobody's rights were violated. The law was followed during this investigation. You're going to hear Adam Fox here talking with, not talking with, but rather messaging Eric Molitor.
No, that's not an issue at all. You'll have your own unit. We will be statewide. We're actually going to be plugging out nationwide. We got this shit popping off like right now in like Delaware. There's a few other states. We're just going to build a unit. Like, you're going to have your own unit, your own local community, and then we'll all get together, like every couple months and train as a fucking state. We'll figure it out, dude. We're just going to build a real fucking unit. No more social clubs. No more fucking ego tooting. Like, we're going to build a real unit that's here. We're not even going to call ourselves a fucking militia, dude, because we're just going to be a civilian army. Shut up! My bad, man. It's fucking dogs. Anyways, man, it's going to be righteous. I'm looking for people to grow. There's going to be no chain of command. We're all going to be equals. I want everyone's input. I want everything to run smoothly. The only thing I don't want is weak people who are uncommitted.
That was Adam Fox asking Eric Molitor to join his civilian army. This is Eric Molitor's immediate reply back to Adam Fox.
Bro, I just got goosebumps listening to that shit. That is everything that I want to fucking do. Exactly the way I want to fucking do it. I am 110% on board with this idea.
Eric Molitor was 110% on board. Here's the response from Adam Fox telling Eric Molitor, you're part of it now.
Well, I'm fucking doing it, man. So you're part of it now. And now we just grow our shit. I got a meeting on Saturday out of state with some guys. So once after that meeting, I'll come back. Dude, we might be doing some real fucking cowboy shit here in the near future.
The meeting out of state that he was talking about, if you notice, it's June 4th when that message was sent. June 6th is a meeting down in Dublin, Ohio with Barry Croft and the other state militia leaders that want to kick off a civil war. This is Adam Fox to Eric Molitor. Eric Molitor knew exactly what he was
calling ourselves second continental for a reason. George Washington's army was the first continental. We are now the second continental. We're going to take back what's ours, bro.
They saw themselves as the new founding fathers. That's an example of that. Here's a post by Barry Croft on the 15th of July where he says, and remember he's the gentleman from Delaware, and he's the national militia leader. At this point, militia resources should not be allocated for rallies and flag waving events. Total waste of good training time. Eric Molitor's response to that was, agreed. We tried it peacefully. We tried calling, writing, emailing. When our little protest didn't work, we all met up in Virginia, and we know how that went. No more rallies or protests. If it's time, it's time. We didn't make it this way. We were pushed and mocked. Done. By the middle of July, Eric Molitor had had enough. So the first event that brought these three threat streams together was Barry Croft's new founding fathers meeting in Dublin. They met in a conference room in the Drury Inn. Bill Knoll and Adam Fox attended this meeting. And listen to these audio clips and ask and it'll be very enlightening, I think the evidence will be, in terms of what their intents were.
So, we have to take action. There are levels of action. Sharing the information, utilizing all those tools. I'm gonna go hurt people. I'm gonna go hurt people real fucking big, and I apologize. I'm sorry. I'm gonna burn motherfucking houses down and blow shit up. I'm gonna do some of those nasty, disgusting things that you have ever read about me in the history of your life. I like them. Now listen, and I'm sorry for that. I really am. Well, no, because it's wrong. Because when I get in this whole community, and I have to break that problem that is why. I've already asked permission to stay grateful. I'm not worried about it anything. I'm not even going to give it a second thought. If I have to fly through a motherfucker, burning this whole motherfucking family to the ground, knowing that I have one myself, I'm sorry. But I'm going to do it.
When Barry Croft made those statements, Adam Fox and Bill Knoll were in the room, and this is Adam Fox's response to that.
We get it all at the same time we say copy. There you have that. And people like this with that, right? Are they going to not just they can bring more voting. Now we actually have something that's valuable that we have that we're talking about.
What he's talking about there, when he uses the word tyrants, you'll learn during the course of this trial, that's kind of a code word for anybody from elected office or any public official or any law enforcement officer. This is Bill Knoll's response to after hearing both Mr. Croft and Adam Fox talk in that jury and conference room.
I did everybody here. Well, I don't know if you were there on the day we went to the Capitol. I'm telling you, yeah, I went in there and I talked with the rally to go to the Capitol. I have across the country. Every fucking place walk down the Capitol. Good fucking the first guy gone. So I'm telling you, you make a plan. You need to make an effort.
We make a plan, and we need to make a network, okay? The threat streams are coming together now at this point. Shortly thereafter, you're going to hear about CHS Dan, rather. And the FBI learned that Adam Fox was attempting to acquire explosives. And let me back out for a little bit here. CHS Dan is short for Confidential Human Source. Okay, and Dan is going to testify for you. He's a gentleman who is an Army veteran and has served our country. He worked for the U.S. Postal Service as a contractor in delivery of the U.S. mail, and he found the Wolverine Watchman on Facebook and was allowed to enter one of their private chat rooms after he was vetted, and immediately identified the fact that he had probably entered something he didn't want to get into because he saw they were talking about killing law enforcement, and saw that they had illegal weapons. Contacted an individual in his local community who was a police officer who referred him to Special Agent Henrik Impola, who's going to be one of our witnesses. And CHS Dan became the eyes and ears, if you will, of this investigation early on. Now, during the course of the investigation and going into the summer of 2020, Adam Fox began to express a desire to acquire explosives. He actually wanted to blow up the bridge, the Elk River Bridge in Elk Rapids. And the reason he wanted to do that is because he believed that would slow down the police response to his attack that he had planned on the governor's cottage and on Birch Lake. Okay? And obviously, during the course of this investigation, the investigators from the FBI and the Michigan State Police, the last thing that they wanted Adam Fox to do was to actually get a hold of real explosives. And Adam Fox was talking about the baker that he was going to get these explosives from. The FBI inserted an undercover agent, and you're going to hear from Undercover Red, into the investigation, and the reason they did was twofold. One, Red was brought in under the guise of oh, I'm an explosives guy, I can get you explosives, okay? Now, if he's Adam Fox's new explosives contact, law enforcement and the investigators know that Adam Fox will never get explosives through Red because he's obviously a sworn law enforcement officer. And the other thing Red does is he gives a little more coverage to the investigation, if you will, than what CHS Dan was able to do as a single person. Here is an audio clip of undercover Red being recruited by Adam Fox on July 3rd, 2020, the first day that Adam Fox met undercover Red.
And that's why I try to tell all my men to get them mentally prepared. Like, you have to be prepared because that's what they're going to do. And if we don't do now, if we don't act, it doesn't matter. In a matter of months, we'll all be criminals anyways. We'll be criminals because we want to keep our rights. And us wanting to bear arms to protect all our constitutional rights is going to be construed as being criminals. So we're going to label those criminals as months.
And here's the thing, man. When criminals...
As long as we stay within the bounds of the Constitution, we will not be criminals. We will only be criminals in the eyes of their unjust, unconstitutional laws.
100%.
In the eyes of my God, I will die a fucking saint.
How did that?
Covered in blood.
Adam Fox was fairly plain spoken. The Wolverine Watchmen and the Knoll twins attended a national training exercise in Cambria, Wisconsin that I touched on. They were invited to attend by Adam Fox, and the field training exercise included live fire weapons training, breaching and clearing a kill house, and combat medical care. Not first aid like CPR, or if you've cut yourself, what to do in the event that a person was shot. The FTX was actually a cover for Adam Fox, and he attended, and Barry Croft, he attended, and the Knoll brothers attended too. And it was a cover for them to do a couple different things. One, recruit, and two, continue to train in anticipation of the attack here in Antrim County, and to refine their national attack planning. And you're going to see in this next video Mike Knoll working hand in hand with Adam Fox in a maneuver sometimes referred to as leaping and bounding, while one individual shoots and pins down the adversary with gunfire. His teammate moves to a position of tactical advantage. My apologies. We'll get to that in a moment. During the training, Barry Croft announced that they'd be targeting Governor Whitmer in Michigan.
We have a quick, precise grab on that fucking governor. And all you're going to fucking end up having to possibly take out is her arm. With her arm door. All I'm going to have to possibly do.
Okay. I'm going to stop here for just a second and point something out. I think the testimony is going to be there's over 150, close to 160 hours of recorded evidence in this case. Okay? We have selected what we believe to be relevant portions of those recordings of the different individuals that are part of this investigation for you to listen to. Okay? If anybody believes that we have taken anything out of context, they're allowed to, the defense is, put in what they believe fills in any gaps. Okay? So if anybody tries to tell you that we're cherry picking,
Objection, Your Honor. Burden shifting. Objection.
The attorneys all approach, please. back on the record, the objection, as I understood it, is burden shifting. Is that correct, Mr. Nunzio?
That is correct, Your Honor.
And Mr. Sider, are you joining that objection?
I would join.
Mr. Barnett?
For the record, yes.
Any response, Mr. Ross?
I don't believe it is, Judge. Under the rule of law, the rule of completeness, which is a rule of law, they would be allowed to correct anything that if they think that I'm misrepresenting anything to the jury.
Well, ladies and gentlemen, let me take this opportunity to let you know a couple of things. There are rules of evidence. You'll hear those referenced. You may hear an objection followed by a number, for example, that would be tied to a particular rule of evidence. The attorneys certainly can do that. It's perfectly appropriate, as was just done by Mr. Nunzio, joined by the other defense attorneys. Then what happens is the other party, whether it's the prosecutor or one of the other defense attorneys, would be allowed a response. In this case, the objection is burden shifting, and so I want to be very clear. I'm going to overrule the objection. What Mr. Walton was talking about is some of the interactions with the rules of evidence and how they apply. But I also want to be very clear with all of you. You heard me say in the instructions, and it will be in the final instructions again. The defense attorneys and the defendants do not have to prove anything. They don't have to prove their innocence. They don't have to, quite frankly, do anything. Everybody sitting at those tables could just sit there the entire duration for the trial. You could not use that against them. In fact, let's say one of the defendants doesn't testify. Let's say none of them testify. You will be specifically instructed. That is their constitutional right, as it would be for all of you, as it would be for all of us. And you cannot use that or hold it against them in their deliberations. So I want to be very clear about the distinction. What Mr. Ralston was simply referring to are the rules of evidence and some of the ways that they interact. It does not shift the burden to the defense. They do not have to prove or do anything. Okay? Thank you. With that, Mr. Ralston.
Thank you, Judge. This next clip you're going to see here is during the training, team members practice that movement under fire. And this is Mike Knoll and Adam Fox working together.
Am I ready? Good. Lights out, baby! Oh. Love it.
The evidence is going to show you, ladies and gentlemen, that these men were serious about their business. They had serious weapons. They had the ability to do what they wanted to do. That was at the Wisconsin field training exercise in July. Again, Barry Croft attended it. We see him here in his what they call kit with body armor, his long gun, his sidearm, multiple magazines. While they were there, and while Barry Croft was there, and Adam Fox, and the Knoll twins in Cambria, Wisconsin for this FTX. Barry Croft, along with the Wolverine Watchman members, so you see in this picture, Mr. Croft on the right, two Wolverine Watchman members on the left, attempted to assemble a improvised explosive device with shrapnel inside it to test its destructive capabilities. Although it didn't work very well, you're going to learn during the course of the trial that Mr. Croft's skills improved. And this audio clip here is his 10-year-old daughter approaching them while he was making explosives.
Daddy,
What, honey?
you want to
Honey, I'm making explosives. Can you get away from me, please? Yeah, thank you. I love you. Some things you just can't do with pop. Man.
Barry Croft, you're going to learn through the evidence in this case, took his mission to kick off the Boogaloo or the next Civil War very seriously. Here we have Mike Knoll in 26th of 2020. He posts on Facebook, Civil War getting closer every day. Closer and closer every day. Okay, let's talk a little bit about the daytime surveillance. Again, this happened on the 29th of August of 2020, and CHS Dan and Adam Fox picked up Eric Molitor in Cadillac, and the governor has a protection detail of very dedicated Michigan state troopers who are sworn to protect her, and if necessary, give their life in pursuit of that goal. So I mentioned they got to the edge of the governor's driveway. When they got to Antrim County on this daytime surveillance, they wanted to make sure, the investigators to this case wanted to make sure that they had some control of the environment, that if Adam Fox or Eric Molitor wanted to conduct the attack that day, that they would have some ability to limit that. So they told CHS Dan that he would have to drive, and that if anything happened, like if they were pulled over by the police, just on a chance encounter, Dan was instructed, you make sure you comply with the officer's requests, you do everything you can to limit their desire to conduct an attack on that day. The invitation from Adam Fox to Eric Molitor to participate in this surveillance was done through electronic communication. And this was learned by the investigation actually after the investigation concluded with the arrest of the defendants, okay? The point that I'm trying to draw you to here is when Adam Fox and CHS Dan pick up Eric Molitor in Cadillac in June, none of the investigators, knew who Eric Molitor was. It was a new person that was entering the subjects of the investigation stream, if you will. So the invite was 2 days before, hey, want to go for a ride Saturday and do some recon? We're doing some recon in Alpha Fox's, Adam Fox's handle. We're doing some recon on a high-profile vacation house. And he says, okay, well, we may get pulled to Detroit, and this was for some other protests that were going on. Just us with the boys. OPSEC reasons, cash for food. They didn't want to leave any electronic footprint. Low profile, no trail of our existence there. The day before, Adam Fox says we have 3 locations. We have intel on 3 already. We're knocking out 1 and 2 tomorrow. Adam Fox had 3 potential targets. You're going to hear about those during the course of the trial. 1 was the governor's residence in Lansing. 2 was the governor's residence on Mackinac Island. And 3 was the governor's private residence on Birch Lake here in Antrim County. And that eventually became the target they selected. And the reason they did, and they evaluated it correctly, that would be the easiest place to do what they want to do. They would meet the least resistance. Okay, the daytime surveillance. When Molitor was picked up by Fox and CHS Dan, he was immediately told of the plan to surveil the governor's cabin here in Antrim County. And during that surveillance, Molitor stated that he'd not be willing to participate in the rape or torture of the governor, but suggested several things during the course of the day, and this reconnaissance was over 5 hours in length. They actually had to stop and get lunch at one point. And he said that they ought to consider the location of local law enforcement, like those officers down in Elk Rapids, about 3 miles away, and other law enforcement agencies that might try to stop them. Adam Fox sketched a map of the Birch Lake area during the course of the day, and the neighborhood around Birch Lake. And they identified a neighborhood actually over on the bay that gave them Lake Michigan access. And they talked about how they could use that point of entry onto the water to actually extract, was the word they used, their target onto Lake Michigan. While conducting the surveillance here in Antrim County, after being told what the target was, Eric Molitor actively participated and contributed to Adam Fox's plans after learning the governor was the target. Molitor performed 6 separate Google searches from his phone, searching for the governor's address on Birch Lake. During the surveillance, they eventually find the governor's cabin on Timber Lake Drive, which is basically a north-south dead-end street, runs along the west side of Birch Lake. Okay, and she's actually, and she's closer to the south end of it. And when they found it, Adam Fox wanted help from Eric Molitor, and Eric Molitor provided it. Adam Fox handed Eric Molitor his phone and asked him to take a slow-motion video.
Derek, can you do me a favor? Do slow-mo video real quick. Put this up against that window over there, and then press that button. Do a slow-mo video as people buy it.
Is it just set to do slow-mo?
It's on slow-mo, and I'll hit the button, and then it'll say I should record. I'll do that with slow-mo video as we go by.
And here's the video that Eric Molitor shot for Adam Fox. And let me back out here for a little bit too. You know, the evidence is going to show you during the course of this trial that people who work as a group together as a team, they're a more formidable adversary. They're more dangerous, okay? And it's not just one thing that any individual may do. Like, you know, Eric Molitor's taking the video for Adam Fox there. I mean, he's providing material support. That's what the evidence is going to show you right there. He's providing material support by being there. You know, there's a thing that we think about, you know, and I'm going to give you moral support. Well, you know what? When you show up and you stand next to somebody, even if you don't say a word, that's a form of providing material support to somebody. I mean, we've all done it. We've all gone to funerals. We've all gone to the hospital where we can't talk to the individual. And, you know, being there as a member of the team and in support is a form of material support and personnel. You can provide yourself as personnel. Okay, during the surveillance, they identified the Elk River Bridge. They identified the Elk Rapids Police Department. What you see there is actually the truck where Adam Fox and Eric Molitor are in with Dan, and they actually drove by on Molitor's suggestion, the Elk Rapids Police Department. Okay, let's talk a little bit about the Michigan FTX field training exercise down in Luther. The Wolverine Watchman provided a remote hunting property in Luther, just south of Cadillac, for this regional FTX for people from other states also. And the Wolverine Watchman invited Adam Fox and Barry Croft, who both attended, as did the Knoll brothers and as did Eric Molitor. And the point of this FTX is kind of an extension of what happened in Wisconsin. They're continuing to practice their military skills, and they're continuing to refine their reconnaissance and their attack plan on the governor's cabin here in Antrim County. Adam Fox invited members of his team, including the Knoll brothers, through Bill Knoll, to participate in a nighttime surveillance. Now, undercover agents and CHS Dan were there during this FTX, and the Wolverine Watchman actually worked for several weeks to prepare this property. I mean, they created, we'll show you evidence, they created a shooting range, they had a kill house that was meant to help them practice entering the governor's home and killing her security detail. And this was all in preparation for the attack on Governor Whitmer's cabin. This is a video here of Bill Knoll enters first, and then you'll see Mike Knoll follow on, and towards the end, and they're entering the kill house, which is made up of their blue tarps, and so that they have a feeling of a room and hallways, and they can practice how to enter and use offensive military tactics, essentially. During the course of this FTX, Adam Fox, Bill Null, and Mike Null trained with firearms. I mean, remember, felony firearm is one of the charges. Not only providing material support for a terroristic act, but also having a gun when doing so. Eric Molitor, during the daytime surveillance, had a pistol with him. You're going to hear testimony about that. During these the Saturday training in Luther, the Michigan FTX, if you will, Adam Fox pulled aside Bill Null and undercover Mark and told him about his plan to conduct nighttime surveillance on the governor's cottage on Birch Lake that night. And Bill Null was on board. Mike Null was not present for this particular conversation. Okay. And Fox identified Governor Whitmer as the target. The point that we talked about on Monday, that actions speak louder than words. Although Mike Null wasn't present for the invitation by Adam Fox to participate in the nighttime surveillance like his brother Bill was, when it came time that evening to go to the nighttime surveillance, Bill Null didn't show up by himself. He showed up with Mike Null. I suggest to you the evidence is going to show you that Mike Null knew exactly what he was getting into. Let's turn to Eric Molitor for a minute here. Eric Molitor had this radio frequency detector, okay? And what this thing does, as I mentioned it before, is if you have a listening device or recording device on your person that emits, a radio frequency of some type, this device will find it. And if you're an undercover special agent, or if you're somebody like Dan who's trying to, help an investigation, and you got a listening device on you, this can be a very dangerous piece of equipment. This is highly valuable to Adam Fox, and you're going to see here, Adam Fox didn't ask once, twice, but rather 3 times for Eric Molitor to bring his radio frequency detector to this FTX that happened in September in 2020. Bring your security toy to FTX, please. We need to use it. Hey, make sure you bring that scanning device, bro. That's 2 days later. And then the September 11th, the day before the nighttime surveillance on the governor's cottage. What's up? We're on our way now. Going to need that device you have tomorrow morning in Walmart parking lot. Barricade, that's Eric Molitor's handle. See you there. He doesn't have any objections. This is the device itself. And you can imagine that if you were an undercover special agent in an investigation, or somebody like Dan, who's just a civilian trying to do his part, seeing something like that would not be a happy day for you. They used it, in fact, to scan participants during the FTX. Okay, Barry Croft, Eric Molitor. Eric Molitor just didn't bring himself. He didn't just bring his specialized equipment in the form of a radio frequency detector. He also brought a pretty unique skill set. He fancied himself as a very serious medic, okay? And medics in combat environments are a little bit different than the paramedics who might come to our home if we have a medical emergency. I mean, they're trained similarly, but they have different tools. They have things that are called Israeli bandages and deep compression bandages and things to treat combat injuries like bullet wounds or knife wounds, okay? Not the typical, I burned myself in the kitchen and I have an issue. Eric Molitor provided himself as a medic during this field training exercise in September. This is the field training exercise when the nighttime surveillance was conducted. And he provided himself as a medic during the kill house exercise. that you saw a little bit ago. He stood by with his medical kit and was ready to, lend aid if necessary. And he also provided himself as a medic on Sunday. Remember, Barry Croft was up in Wisconsin trying to put that IED together, an improvised explosive device. I showed you that clip with the daughter coming up and saying, "Daddy, do you want a Dorito?" That one didn't work very well. When he got to Luther, he figured it out. The device that went off at Luther worked. Okay, I mean, it was a significant explosion. You're going to hear testimony about that. Okay, let's talk a little bit about the nighttime surveillance. Fox assembled his team, and they all went to the Cadillac Walmart. Okay, because remember, they're in Luther, they're south of Cadillac a little bit. Now, Eric Molitor didn't go on the nighttime surveillance up to Elk Rapids and here in Antrim County. He participated in the FTX that weekend, but he didn't participate in the actual surveillance itself. And he arrived at the Cadillac Walmart, though, and the reason he did was because he had his radio frequency detector, and Adam Fox wanted to use it on the nighttime surveillance. And so Eric Molitor actually drove up to Cadillac and provided that to Adam Fox, and they used that evening. They were in 3 vehicles. They came up here to Antrim County from Cadillac, and they stopped at the American Veterans Post in Elk Rapids there, just south of the bridge, west of 31, next to the Easy Mart. And Fox, when they got there, the 3 cars, Fox handed out team assignments. One car was to go down the governor's street, and while doing so, flashing its lights, called that the signal car. Another car was going to be a spotter car, and they were going to go to the north end of Birch Lake where there's a public boat launch, and they were going to see if they could see the flashing of the lights of the signal car, because then they could get an orientation on, because their plan was to go in by boat. So they'd be able to get an orientation of where the governor's residence was on the lake. And then finally, the car that the Knoll brothers were in was a counter-surveillance car, or a surveillance car, or a lookout car. And what their mission was that night, essentially, was to make sure that if a state trooper, a regular patrol officer, or a county deputy sheriff was in the area, they could communicate to the other 2 cars about that threat to them. Undercover Red participated in this. And this next clip you're going to hear is Fox talking to the Knoll brothers as they're sitting in the Walmart parking lot down in Cadillac before they drove up to Elk Rapids.
This is Joe. Everyone else is sitting in the fucking parking lot and goddamn 10 o'clock at night on a fucking Saturday night. Who might even go do recon? Anybody go do recon anything? Fuck no. We've done tons of it in the past like 1 month or so.
This is Fox talking to the Knoll brothers about that little town of Elk Rapids.
This would be about the only place we do. We recon residents on hand. So we done, but so more or less this, we got very heavy security detail there with a lot of fucking supplies. Do not know where they're staged, okay? 2 is potentially dealing with the fucking poster. Here, it's a little town right there. There's a little bridge that goes over. We're gonna blow that fucking bridge, and there's like no way for the cops to get around everything. Most besides that are like 20 plus miles in all directions. Okay, so it gives us maybe a 15 minute head to start legally. By that time, we can have the ditch in the fucking boat, and we know fucking legal shit.
That's one of the 2 men that Bill Knoll and Mike Knoll and Eric Molitor were willing to help. Placement of explosives under the Elk River Bridge. Undercover Red is now there at that FTX. He's been introduced as part of the investigation. He's the person that, I'm your explosives expert, I'll get you what you need, but I'm never going to deliver it to you, actually. That's how they made sure that Adam Fox wouldn't get any real explosives. Okay, well, while he's up there with Adam Fox, and you all know the Elk River Bridge, and that's a picture of Adam Fox under the Elk River Bridge taking a picture of the support structure, and this is from Undercover Red, who took a picture of Adam Fox taking the picture of the bridge. And this is how serious Adam Fox is. At just about midnight on September the 11th, 2020, he's climbing around underneath the Elk River Bridge trying to figure out where he'd put his explosives. That, ladies and gentlemen, is how these defendants ended up conducting surveillance on Adam Fox and Barry Croft, with Adam Fox and Barry Croft on Birch Lake here in Antrim County. What they didn't know was that the Elk Rapids Police Chief, Dave Centella, lived 3 doors south of the governor in her house on Birch Lake. And in fact, when they went down the street here, they actually drove by Dave's house. And it's a location they passed on their nighttime surveillance.
Oh, here's some fireline numbers, these green signs up there.
Okay. Again, you can tell a lot by what a person does. Okay? Actions speak louder than words. And, Eric Molitor, I've told you a little bit about what his contributions were to this plot of Adam Fox and Barry Croft to kill our governor and the state troopers protecting her and anybody from the Elk Rapids Police Department or the Antrim County Sheriff's Department who came along and tried to stop him. Okay? And these men were about serious business. But that wasn't just enough for Eric Molitor, because Eric Molitor actually wanted to go down the line of succession, if you will. In the state of Michigan, just like in the U.S., we have a governor, and if God forbid something should happen to a sitting governor, then the lieutenant governor is there to step in, much like the vice president does. That's part of our Constitution. And after the Luther FTX in September, the nighttime surveillance, he's trying to figure out who the sitting lieutenant governor is. And I suggest to you that the evidence is going to show you the reason he's doing that is because once they get done with Governor Whitmer, they're moving on to the next one. Again, these men wanted to be the deciders. Okay? At the end, they wanted to be the ones who made the decisions because they had the most guns and they were willing to use violence. Okay, almost done here. Let's look at the Knoll brothers and their actions. They traveled to the new Founding Fathers meeting, Bill did rather, down in Dublin, Ohio on the 6th of June. They practiced operational security. They were religious about it. They attended the Wisconsin FTX. Remember, Barry Croft and Adam Fox were there too. And they trained in Cambria with both. They went to the Luther FTX again, where Croft and Fox were at, and members of the Wolverine Watchmen. This is the 3 threat streams coming together. Okay. The nighttime surveillance, it furthered the plot to kidnap Governor Whitmer, and it furthered killing law enforcement, which they weren't afraid to do, and it furthered the idea of the demolition of the Elk River Bridge. They were going to be operators on Adam Fox's team. Okay, they were supplying themselves. Molitor's actions, he covered for Fox's work shift when Fox went to Barry Croft's new Founding Fathers meeting down in Dublin, knowing what he was going for. You heard the audio clip. He practiced operational security too, and was very adamant about it. He participated in the daytime surveillance directly, armed with a gun. He came here to Antrim County to help Adam Fox surveil the governor's house during the daytime, and took the slow motion video that I showed you and also proposed refinements to the plan of how they were going to attack the governor. He went to the Luther FTX. He provided that radio frequency detector to scan participants, and he scanned people himself. He acted as a medic in those 2 environments I described. He also provided his RF detector to Adam Fox for the nighttime surveillance. And finally, he was acting as the medic on Adam Fox's team. So let's real quickly look at providing material support again. I think at the end of this trial, you're going to be convinced beyond a reasonable doubt that these defendants provided that material support to Adam Fox and or Barry Croft in the ways that I've described here for just a little over an hour. And they knew what the plan was about, ladies and gentlemen. It wasn't like they gave somebody $100 because they looked like the guy was down on his luck. They knew what Adam Fox and Barry Croft were all about. They knew that those two individuals would use that support to help them plan for the attack on the governor and her security detail and anybody else who responded right here in Antrim County. There's no doubt that this was going to be an act of terrorism. Felony firearm has only two elements too, and again, that they possessed a firearm, or that they committed the crime of providing material support for a act of terrorism, and when they did so, they had a weapon. You've been very kind, very patient, listening to me, and that means the world to me. I thank you. Not a word I've said is evidence. I've shown you what I think is going to be some of the evidence in the case. I mean, there's going to be north of 200 exhibits here. We're going to move through them one at a time, one question at a time, one answer at a time. We're going to respect your time. We're going to try to get through it as efficiently as possible. And I'd ask that you pay close attention. And when we return here for closing arguments, I'll be asking you to return a guilty verdict. Now, it's not required, but if the defendants want to make an opening statement, they can. And I ask that you give them the same kind attention that you've given me this morning. I appreciate it very much. Thank you.
Okay, thank you, Mr. Wilson. We're going to take a short break. And while we do that, ladies and gentlemen, we're going to give you some menus from which you can select the lunch that you would like. And so we'll go take a short break. While you do that, I'm guessing it'll just be a quick one, 5 to 10 minutes. But obviously, feel free to use the restroom, all of those things. And the other thing is, when Mr. Gardner or anybody else knocks to see if the jury is ready to come back in, if one of you could just let us know if somebody's in the restroom, what we're looking for is if all 18 are ready to go. And so if somebody needs another minute, just let us know that so that way everybody can come back in. Okay, thank you. All rise for the jury. Okay, you can see it. The record can reflect that the jury is out of the courtroom. Let me just start with Mr. Nunzio. Obviously, the defendants have the option of giving a motion statement, or you can reserve it. Let me begin with you. Do you intend to give one this morning?
Christina Nunzio intends to do an opening this morning, Your Honor.
Okay. And Mr. Seibert?
Judge, I'll be reserving.
Mr. Burnett?
Yes, Your Honor.
You'll be giving one this morning? Okay.
Yes.
Mr. Nunzio, I would begin with you. I'm not holding you to a time limit. My thought would be to release everybody for lunch and to have the openings for you and Mr. Barnett after lunch. I don't want you to feel constrained, and I want everybody to pay as much attention as possible. So, any objection to that?
No, I agree, and I thank you, Your Honor. I don't want the jury thinking like, oh, I gotta get to lunch, I'm hungry. So I really appreciate that consideration.
Okay, Mr. Barnett, any issue with that? So what we'll do is give them about 5 or 10 minutes to get their selection for lunch down. My thought would be to have everybody come back ready to go at 1 o'clock. I assumed you all had prepared openings, so you shouldn't get longer to lunch today. And so we'll take a quick break. I would like to see the attorneys in chamber.
Lights are sending out. Microphone's working. It's all working.
What was that? He's like, okay, we're going to take a 5-minute break. They're going to choose what they want. And then they said, next part, so it's going to start until after lunch.
I'm sorry.
Oh, you're fine. Excuse me. Just to clarify, the way the judge worded it, the jury would be allowed 5 to 10 minutes to select lunch, but then you assume will happen at 1 o'clock. Are we coming back? So we're just in flat recess.
They're going to come back in and formally excuse, but not actually.
Okay. Gotcha.
Let's wait for that. No problem. Create no problems for you. No problems for you. I'll give you a card after. We'll know 3 weeks.
So the video that I just texted you, that I got,
And like we had that.
I got this completely the other day. I learned just because I was requested by some government agents that are in the building. Anyone else in the building right now? Space is out there all over the place. Like, library, just of them.
Thank you.
Where are we going to eat?
This video when you're opening.
Well, that's all Watchmen specific, right? I mean, we're talking about these defendants.
Oh. Oh, okay.
Trying to stay on focus.
I
On
did
the
blur his
target.
face out, even though
Yeah.
anyone else can FOIA it and get his face.
No, thank you. Yeah, I appreciate it. That's a huge deal.
You
know.
saw the email I forwarded.
I
you,
did.
right?
I saw
With
the
all the
email.
other images of him out
Yeah,
there.
yeah, I did. Yep, I saw
There's
that.
still live links.
I know, but a lot of people follow you. So, yeah. So, I appreciate it.
Those are still streaming with audio.
Yeah.
Messages from the office.
Copy that. Hey, Alex. How's it going, Alex? You guys talked to Alex recently? Oh, yeah. Yeah, what do you think of Danielle?
Let's get everybody back.
Oh, gotcha.
Absolutely amazing.
Yeah. I'm not writing a jury record. Let's go back on the record then. Just a couple of things. If the record can reflect the jury is still outside of the courtroom. I just wanted to give everybody a heads up on a couple of things. Our staff did get a couple of calls from folks that were watching the live stream. So just so you're all aware, when we take a break, they're not necessarily taking a break, so the feed is active the entire time. So just be mindful of the conversations that you're having and the volume at which you're having them. Nothing inappropriate was relayed or anything along those lines. I just want everybody to be aware. The other part is someone called before it did indicate that they thought maybe one of the jurors was shown on a break because the camera angle panned out or something like that. If it was on a break, the jury wouldn't have been in the courtroom. So what I assumed was that, what I assume happened is maybe one of the cameras panned out to get more of the courtroom or something along those lines. I don't say it to accuse anybody of anything. I don't think anyone did anything inappropriate. My point is simply just to remind everybody to make sure that they're keeping all of the rules in mind because it could be one of those things that's just inadvertent, and that's what we want to avoid. Okay? It's my understanding the jurors have made their selection. Given that it's noon and the amount of meals that are going to have to be prepared and basically everybody using limited resources in order to go get lunch, what I'm going to do is we're going to come back at 1:30, so it'll be 90 minutes for lunch to make sure that everyone has time to be able to do that without rushing. Okay? All rise for the jury. So, ladies and gentlemen, thank you for making your selections. What we're going to do now is break for lunch. Given sort of the limited number of options available for folks, I don't want people having to race around. I know the parking situation is horrendous around here anyway, and so people could probably take a full hour trying to find a parking spot. So what we're going to do is actually take about 90 minutes. So your food will be brought in for you, but I want to make sure that the attorneys and everybody else has time to do that and then any work that they need as well. So we're going to start back up at 1:30. What I would ask is that you at least wait in the jury room until your food has been brought and then you eat. Again, the rules, I'm not trying to trap you in this building, but anytime that you're in here or around it, meaning on the campus, you do need to be inside the jury room. And that is protection for you in this process to ensure that nobody has a conversation, even unintentionally, within your reach. But if you want to, for example, after you eat, go take a walk, that's perfectly appropriate. Make sure you wear your juror badge outside the building. of not talking about the case with anyone, not posting about it, et cetera, all of those still apply, obviously, and all of those protections as well. And then just make sure you're back here within enough time so that we can get started right at 1:30. Okay, any questions for any of you about how we proceed for lunch? Okay, thank you. All rise for the jury. Okay, you can all be seated. That sounds like it. Okay, the record can reflect that the jury is outside of the courtroom. We'll come back at 1:30, at which time Ms. Nunzio, I believe, is going to give an opening statement on behalf of William Null. Mr. Cyber, you indicated you were going to reserve. Is that correct?
Yes, Judge.
Okay, and then Mr. Barnett will then be allowed, obviously, to give an opening on behalf of Mr. Molitor. I don't know how long both of those will take, so we may take a short break, but I would ask the Attorney General's office to obviously be prepared at that point to go into their first witness. We'll have some daylight left, so to speak, and plenty of time to be able to do that this afternoon.
We're ready, Judge.
Anything for anybody before we take a break? Let me start with you, Mr. Ralston.
No, sir.
No, thank you.
Mr. Seiler.
No, thank you.
Mr. Barnett. Okay, thank you all. We'll see you back.
All right.